Good morning, everyone. We are here today to tell you about the 1987 Philippine Constitution, Article 3, the Bill of Rights. Section 1. No person shall be deprived of life, liberty, or property without due process of the law, nor shall any person shall be denied the equal protection of the laws. Section 2. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches of seizures of whatever nature or for any purpose shall be avoidable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination, under oath of affirmation of the complainant and the witness to be processed, and particularly describing the place to be searched and the persons or things to be seized. Section 3. 1. The privacy of communication and correspondence shall be avoidable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by the law. 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any possible in any proceeding. 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in the proceeding. Section 4. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. Section 5. No law shall be made respectively. Section 5. No law shall be made respecting any establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. Section 6. The liberty of abode and of changing the same within the limits of prescribed by the law shall not be impaired, except upon the lawful order of the court. Neither shall be the right to travel be impaired, except in the interest of national security, public safety, or public health, or as may be provided by the law.
The 1987 Philippine Constitution, Article 3, Bill of Rights. Section 7. The right of the people to information of matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizen, subject to such limitation as may be provided by law. In this section, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. For example, if you are a public servant or a normal citizen, we will have a rights in spreading public news, in order that others knows the news and always follow in the law. Section 8. The right of the people, including those employed in the public and private sector, to form unions, associations, or societies for purposes not contrary to law, shall be abridged. In this section, it is the right of people from private and public sector in joining and creating a association or organization. For example, if a person is in private sector, they can join every organization or unions in their place and freely connect every person. Section 9. Private property shall not be taken for public use without just compensation. Section 9 means that a private property will use with the permission of the owner and private compensation. For example, if we will occupy the space in a private places like business, we can use it without permission and in the same places. Section 10. No law impairing the application of contracts shall be passed. So in this section, it means that a law is impairing in the line of obligation of contracts. There is no problem in contracts if we follow what is in the contracts. For example, if we borrow money from a cooperative, we follow our obligations, we follow our contracts, and we follow the law. Section 11. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. So, in Section 11, it means that every person, rich or poor, will have a fair and legal assistance without reasons of life. In the line of justice, no rich, no poor, but justice is fair to us.
Section 12, number 1. Any person under investigation for the commission of an offense should have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. This right cannot be waived except in writing and in the presence of counsel. Number 2. No torture, force, violence, threat, intimidation, or any other means which violate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Number 3. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. Number 4. The law shall provide for penal and civil sanction for the violation of this section as well as compensation to and rehabilitation of victims of torture or similar practices and their families. Section 13. All persons except those charged with offense punishable by reclusion perpetua when evidence of guilt is strong shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. Section 14, number 1. No person shall be held to answer for a criminal offense without due process of law. Number 2. In all criminal prosecution, the accused shall be presumed innocent until the contrary.
Article 3, Bill of Rights, Section 18. No person shall be detained solely by reason of his political beliefs and aspiration. Number 2. No involuntary servitude in any form shall exist except a punishment for a crime whereof party shall be duly convicted. The first part of the provision deals with the right not to detain by reason solely by political beliefs and aspiration. This essential embody the freedom of expression but with emphasis of prohibition against incarceration of political prisoners, where in the second part of this section deals with the right against involuntary servitude. Involuntary servitude refers to the compulsory service of another or simply modern day slavery. The rights is based on the egalitarian principle of democracy, which prescribe equality, everyone in law, and humanity, which prevents degradation of human dignity through enforced labor. Section 19. 1. Excessive fitness shall not be imposed nor cruel regarding inhuman punishment and flight. Neither shall the death penalty be imposed unless for compelling reasons involving numerous crimes and Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. Number 2. Employment of physical, psychological, and regarding punishment against any prisoner or detained or use of substandard or inadequate penal facilities under subhuman condition shall dealt with by law. Under the section 19, the death penalty, the court will be justified in declaring fine prescribed by statute excessive only when it is declared so considering the nature of offense and the ability of a person punished to pay the fine. It can be said that punishment are cruel and inhuman when they involve torture, lingering death such as burning alive, motivation, starvation, lowering and other barbarous punishment. Punishment is regarding when it brings in shame, humiliation of the victim, or expose his component or ridicule of lawless, his dignity and self-aspect as a human. Article 3, Section 20. No person shall be imprisoned for debt or non-payment of a poll tax. It's not literally mean that when be in prison or you will not face any consequence, but the victim of or not paying the tax can file you a case, just like estafa. Estafa means it's not convert constitution guarantee. What is punished estafa is not a non-paying of debt, but they say accompanying of act of non-paying. Non-paying of poll tax cannot be a cause of imprisonment. A poll tax is a tax of fixed amount imposed of individuals residing within specific territory, where citizens were not without regard of their property, occupation in which engage. Community tax, resident tax, example of poll tax. That's all. Then, Section 21. The person shall be twice put in a judiciary of punishment for the same offense, and act punished by law and ordinance. Conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Double jeopardy means that a person is twice put at risk of conviction for the same or offense, act or offense. The right against double jeopardy therefore means that a person can only be enacted in one charge once by competent court for an offense. When a person is, for instance, has been charged of homicide and the court acquitted him the case, he can no longer be prosecuted for the same offense or act. He can now invoke his right against double jeopardy. Section 22, Article 3 provides that no ex post facto law or bill of attainder shall be enacted. An ex post facto law is one which makes criminal act done before the passage of the law, which was innocent one done and punish such an act. Within this section, application in only criminal case. The constitutional prohibition applies only in criminal case. One, the characteristics of criminal law is prospective, in which only crimes committed after enacted of a penal or punishable. It cannot retroact and push acts which were not yet criminalized before its passage. The basic rule is that before the act be considered an offense or passage or crime, it must first be defined as a crime or penalty must be imposed for it under a law passed by the legislative body. An act therefore is not a crime if there is no law punishing it. In the same vein, a person does not commit a crime no matter how apparently illegal it is. If there is no law defining and punishing it, it is for this reason that ex post facto law is not allowed because it criminalized what was not yet crime during its commission. That's all under the section 22, which says no ex facto law or bill of attainder shall be enacted.